Please, Your Lordship, I appear on behalf of the applicant.
Mr. Koski, this is Maroda appear for the respondent, assisted by Mr. Marondezi.
Thank you. Mr. Hatuikulipi, good morning. Well, we'll be proceeding from where we stopped. I believe that the applicant had completed his evidence in chief.
That is indeed so.
Yes, and Mr. Ipinge.
Mr. Koski, yes. Mr. Hatuikulipi, this is a bail application, or the second bail application on new facts. Do we have the same understanding that for new facts, you are trying to present something that did not exist at the time of your first and the second bail application, or that was at least not available to you? This is to guard against abuse of the process, so that every week you must not bring a new bail application claiming it to be new facts. And for that, you have given your new facts in the notice or set down, or the application for notice of set down to the registrar of the High Court. Now, let us deal with the issue of the trial not having started on the 2nd of October 2023. You testified that this was mainly due to the fact that a new judge was appointed, as the previous judge was taken off the case. That was Justice Miller that was first to handle this matter. And the reason that culminated to his removal, or perhaps a replacement, not a removal, was that there were also challenges from your co-accused persons who wanted him off. They brought recusal applications, although unsuccessful. So that alone was not due to any fault of the state for the judges to be changed. You also testified that the reason also that the trial did not kick off was because of issues of legal representations. The issue that your co-accused, perhaps yourself also by then, were not in funds to appoint lawyers of your own choice. You are still not in funds. Okay. And the reason you are not in funds is because of your assets having been restrained. And this was by a legitimate court order after all processes and legal processes as per the Poker Act were followed. Yes, but at least for, yes, but it was a due process in another court, not even in the criminal court. It is in another court. They are following their own civil route of things per the Poker Act. So also that is not due to the fault of the state that your assets were restrained, but by operation of the law and an application properly brought by the Prosecutor General against you. But those are issues that were also dealt with in one of the bail applications by the Supreme Court. Right. So, now, also, if we look at that restraint order, it does not completely prohibit you from accessing some of your funds, especially for legal processes and for your legal representation, correct? In fact, Mr. Bernard Esau most recently was successful to bring an application for some of the funds to be released up to a tune of 2.3 million for his legal fees. Yes. Not the state. It's a different setup. That's a civil proceeding. Yes.
My learned colleague should be careful not to mislead. It is the state. It's the office of the prosecutor general. Yeah? That is part of the state that appealed that decision. So it means, as far as we are concerned now, the status quo is that the decision of allowing Mr. Esau access to part of his funds, is suspended because of the appeal.
So who are the parties in the appeal?
It is, I'm not very, but the one that is the Prosecutor General's office.
Okay.
I think, yes, it's the one that appealed the decision. So the applicant is correct by saying that it's the state that has appealed against that decision.
Mr. Kinge?
For purposes of criminal proceedings, when I refer to the state, I'm referring to us in our criminal stream, in the progress of the state, of the case which me, Mr. Marondeze, and Mr. Lukibeza are representing the state, and yourself and your co-accused. Perhaps let's just clear that up. So we didn't contribute towards that, to delay this matter, to appeal against that. We didn't contribute to that. It was the PG's office. Okay. Yes, but right. Now, and then also on that, Mr. James Hatuikulipi also brought a similar application, correct? His application was turned down mainly because, one, he failed to be frank to the court. He did not disclose his liabilities to the Namibia Revenue Authorities to a tune of 55 million. That was ground number one. Yes. And secondly, also the court found that there was a possibility that there were other assets that he did not disclose, and thus he could not qualify to access some of the funds that are restrained. So, in other words, what I'm driving to here is you, in that position, are also at liberty to bring such an application, and if you are frank enough to the court, you might end up with an order similar to that of Mr. Esau. Yes, and you have brought this application as well. You needed funds also. In this case alone, you have brought a bail application that took more than 2 months. You have brought this one, so clearly your priorities are not with regards to releasing your funds, but rather towards bail applications that you are wasting money on. Previously? Okay. So you can approach them to only assist you with bail applications, but not to bring this application that is so dear to your case, to get funds to legally represent yourself further in this matter. Yeah, seemingly your priorities are only on bail, not other things that can progress this trial from starting. Okay. talking about your priorities. You have approached lawyers to convince them to represent you, whether for free or not, in the bail application. You have not done so to get funds so that you can fund lawyers to start your trial. That you have differentiated your priorities.
I cannot get fund while I'm in prison. It's difficult. That's why I'm looking for bail. Let me first get my liberty, then I can mobilize funds.
Sir, did you understand my question? I'm talking about your priorities. Your priority now is to approach lawyers to bring bail applications, and you have done that twice. In fact, 3 times. In both 3 bail applications, you were legally represented. But you didn't see it fit and necessary and a priority to bring just one application to get your funds so that you can instruct lawyers to start your trial, which is the most important.
My Lord, I don't know why my learned colleague keeps driving on that point. It has been answered. The applicant answered clearly. He said there was an application when he was represented by his extra legal practitioners, but it was withdrawn because after the state opposed. So it's not like the office of the PG, didn't oppose, they opposed it. And the applicant further answered and said that the reason why he's fighting for bail is because he wants to get his liberty, and then that's when he can mobilize funds. It's an issue of funds.
I understand that. It's only that how I understand him is to say he asked you to assist him with the bail application.
Indeed, so, my Lord.
I'm not hearing him to say either he could have asked someone to assist him in terms of an application to access his funds, because that's what your colleague is trying to
May I press the
drive
vote?
at. Yes.
So you find this application is a priority, but an application that will put you in a position to start your trial, you don't find it a priority. That is what I'm driving.
Oh, no, I find it as a priority, but I cannot approach other lawyers because they need funds for them to do that application. Yeah.
Have you approached Mr. Siomunji with that request?
Yes, I did.
To assist you with that application to access funds?
Yes, I did.
What did he say?
No, he say he's a criminal lawyer. He won't be able to do that.
And Mr. Siomunji is a practitioner trained in all fields of the law. I want to believe. Yes. But let us go back also. In November 2013, Justice Chinengu, before whom you are appearing for the main trial, tried his level best to get the trial started by recording pleas from the accused persons.
No, it was December.
That's
correct.
He first requested in November, and then it was postponed to December, correct?
Yeah, November he said whoever is not represented, they are given time to mobilize funds to see if they can get access to funds to keep their lawyers of their choice.
So that the trial can start in December.
In December, that's correct.
Yes. And in December, your legal practitioner, Mr. Siomunji, recorded that he was not ready to give a meaningful plea. In other words, he was only ready for you to tender not guilty, guilty, not guilty, guilty. But he was not going to give a plea explanation as is the norm when you are recording a plea.
That's correct.
So yourself and your legal practitioner by December 2013 were also partly unready.
2023?
Yes. Partly unready to have the trial started.
That was delayed by the legal aid, my lord. So we are waiting for the outcome from the legal aid, my lord.
No. The SMSs that you have produced by 20th of November 2023.
I've got an objection to the line of questioning of my learned colleague and what he's putting across. If he's referring to those proceedings, he must put the facts clearly to this court, because clearly this court was not involved in those proceedings. It's not that there are a myriad of factors why we indicated that, we are not ready to give. In fact, we were not ready to start even the process of pleas. He's narrowing it down to say we were not ready because we are not ready to give a plea explanation. That is not correct.
Well, it's fine, Mr. Siomunyi,
Yes.
because I understand he was still developing his question. And he picked that as one of the reasons. And he had, from what I gather, he hasn't even asked the question that he wants to ask.
Yes, my lord, but I'm saying that the facts that he's placing before your lordship are not correct. We never said we are not ready, that's why we cannot give a plea explanation.
It's fine, Mr. Siomunyi. I've also observed that your client he has a good understanding of what is happening before the courts. So he should be able to answer the question that Mr. Ipinge would ask. In the event the question is unfair, then I'll allow you to make your submissions, because I haven't just heard the question. That's the issue.
May I please the court?
Yes.
But your lordship, all we're just saying is that my learned colleague should just put the correct facts.
Yes,
As
unless
he's
then you
putting
see that your client is also not able to deal with the issue, then I'll allow you to
May I
correct
please
the
the court?
record. Yes.
So maybe let me put it this way. For any other reason, for various reasons, perhaps to you and for your legal practitioner, by the 5th of December 2023, you were not ready to give a meaningful plea or to even start trial by then.
No, I gave my plea. I pleaded. I was ready.
By meaningful plea, I have explained to you, the only thing that you were ready to say is not guilty, not guilty, not guilty, without giving a plea explanation, which is the norm.
Yeah, no, there was no plea explanation, my lord.
Yes. And he says that he was unable to consult you fully so that he's able to give those meaningful plea explanations.
That's correct.
Yes. So, that again was not due to the making of the state. It was between you and your legal practitioner and many other various reasons that your co-accused gave that the trial did not kick off.
Well, the trial kick off.
Yes.
We plead. So the judge said, it's no need to bring your plea explanation now. It's up to you.
Okay.
Yeah. Then you say, we're not going to do that.
So
But we are ready to plead.
are you now changing your first ground to say the trial have kicked off?
No, the plea. We're talking about the plea.
Okay. Yes. So now, immediately thereafter, accused number 10, Mr. Nigel van Wyk, brought a recusal application against the judge.
That's correct.
And that dragged on at least until April this year.
That's correct.
So for that period, the trial could not proceed because the judge was now seized with an application for him to recuse himself.
That's correct.
That was not, and maybe let me address it this way. That application was unsuccessful, correct?
That's correct.
He launched a petition to the Supreme Court.
That's correct.
That was also not even entertained by the Supreme Court.
That's correct. It was
It was-
dismissed.
It was dismissed.
That's correct.
So we can assume that there were no merits in the recusal application because it even failed at the Supreme Court.
That's correct.
So it was a waste of time from one of your co-accused. No making of the state.
Yeah, but my co-accused is just asserting his right. Yeah, I cannot. I was also affected, my lord.
Yes, without
Yeah,
any
because
merits.
I've been always ready to start my trial. So it also affected me.
Yes.
Yeah.
Yes. Asserting his rights without any merits, and then it was even discharged at the Supreme Court.
My lord, I object to that. My learned colleague, surely, is a legal practitioner who has been around these courts for some time. He cannot say things which he has no knowledge of. The Supreme Court didn't give any reasons. If the Supreme Court says this is without merit, my learned colleague is entitled to take that stance. The Supreme Court only wrote one line. The petition is dismissed. He didn't say it has no merits, no reasons were given. So he should just restrict himself to that. It was dismissed by the Supreme Court, period. But to delve into their reasoning to say it had no merits, he has no right to do that. May it please the court.
No? Well, it seems fair.
When a court dismisses an application, it's normally because there's lacking of some sort.
Well,
And there's no merit, because if there is merit, the Supreme Court will not shut its doors. It's our highest court in Namibia. It will not shut its doors to a litigant who have something to bring to them. You know, they do that because the litigant have nothing to bring to their attention.
well, it depends on the issues that were live for determination.
Yes.
You could have a good case on the merits, but if probably you are approaching the court in a wrong way, you may just fail on the first hurdle before you even reach the merits. But I'm not familiar with what could have happened in this case. Yes. But at least I get the gist of what could have happened in that it was not successful.
Thank you. So, and then from there, after this fruitless recusal application was brought, Mr. Shangala brought a string of other applications for legal questions to be determined by the court before the state, before the trial.
That's correct.
Those two have been unsuccessful to date.
That's correct.
They were dismissed.
That's correct.
Yes. So again, from the 2nd of October that you have cited.
And he's petitioning it.
Yes.
There is petitioning those applications
Okay.
to the Supreme Court.
That is good. So from the 2nd of October 2013 to today, the 20th of August 2014, there is no single reason or circumstance that emanated from the state that caused any delay in the starting of this trial.
That's correct.
Now, in fact, on the 16th of August, which is last week Friday, you, your co-accused persons, including Mr. Siomunji, were in court.
That's correct.
After the court had dismissed Mr. Shangala's application, it was now an issue of setting trial dates for the trial to commence.
No. They were consulting each other. When can the trial start?
Yeah.
Yeah, and they were asked, when must, each and everyone was asked, when must the trial start? So all the parties gave their reason, or when the trial should start.
Yes, when the trial should continue.
Correct.
Yes.
Yeah.
It's the same thing. Now, what did Mr. Siomunji indicate? When will you be ready to start trial? Which month of which year did Mr. Siomunji indicate to be available for him to start the trial representing you?
So he said his calendar is now full for the whole year. He thought the trial the dates that were given by scheduling last year of the registrar, it was up to June this year. And he booked those dates for that time now, and the trial did not commence. So for now, his trial is now, his book is now full until next year, February, he said.
February.
Yeah, if my memory serves me well.
Only February, and then from there, when again?
And April.
April.
That's correct.
Yes. What did the state indicate?
They are ready.
Yes. So, again, the reason that this trial is not starting is because you hired a legal representative who is not making himself available to start the trial.
My lord, I object. As I indicated, my learned colleague is being very malicious. He was not there on that day. He should get the record of proceedings. That is not the only reason. He's narrowing it down to just that. My lord, as I indicated, there's a myriad of factors why parties were not ready to start. I have my own reasons. Myself, of course, I indicated I'm only available in February and in April going forward. Mr. Biekes, representing Mr. Iso, indicated he's only available next year. Mr. Shangala and Mr. Hatuikulipi and Mr. Motelulo indicated they are not ready to start because they don't have a lawyer. So he cannot just narrow it down. My learned colleague is being malicious in that he's trying to pin it down to my availability or lack thereof as the reason why we cannot start with the trial this year. And that is not correct. And that's why I indicated, Your Lordship, from the beginning that my learned colleague should place the proper facts before this court.
Is it not that he's narrowing it down to the applicant who is before court? What is his case before the trial court? His circumstances before the trial court? Let me hear Mr.
Please, the court.
Ipinge.
My lord, I find it futile for me to deal with other accused persons while we have an applicant before court. Clearly, my lord, the availability of Mr. Siomunji is not dependent on the availability of Biekes.
Yes.
So I'm going directly to his legal practitioner in his readiness to start trial.
Maybe he's concerned that it may be taken as if he's the reason, he's the only reason why the trial could not proceed.
My lord, is neither here nor there, because even if Biekes was available tomorrow, Mr. Siomunji would not become all of a sudden available.
Well, I thought there was nothing unfair with the question because it pertained to his circumstances as the applicant. He could, of course, extend it to say other practitioners or other co-accused are not ready to proceed if he wants. Yes. Okay.
Yeah.
You may proceed.
So my lord, Mr. Biekes indicated that he will only be ready the whole of next year. Mr. James Hatuikulipi,
He will be ready.
he will be available.
Or available
Yeah,
for the whole of
only
next year.
the whole of next year.
Okay.
Mr. James say will be available. He will be ready for his trial only 2026. Mr. Shangala said next year, middle of next year, I think it's August, same as Mr. Motelulo, my lord. And Mr. Milton gave some dates there that I cannot remember, my lord.
Okay.
But me, I'm ready to start the trial.
But next year?
No, anytime.
Or your legal practitioner, the one that, you know, when you say you are talking also with your defense team, correct?
Yes, but it's not available.
Yes.
Yeah.
So that makes you unready also, because your defense team is not ready to start.
That's correct.
Yes. So you want to create a situation of not starting trial and use that to come before court and say, please grant me bail because the trial is not starting. But this is due to your own creation, or partly there. That is unfair, isn't it?
By the time I testify, my lord, this was not put in motion. We did not deal with this the time I testify. This was only last week on the 16th, like what you say on Friday. Yeah.
No, I'm talking about now. So do you abandon that ground? You say now, yes, I'm partly contributing to the trial not starting. Do you abandon that ground?
No, I don't abandon it.
You don't abandon it.
No.
But it's unfair for you to create a situation and use that as the reason to come to court to be granted bail.
I'm just saying this trial was supposed to start already in October, but it did not commence. Yeah.
Yes.
And from October was not the cause of the delay. Yes.
And when you testified in your examination in chief, you placed great emphasis on you being released so that you can go start businesses, for you to raise funds for your legal practitioners.
That's correct.
Now, you said you have any other hidden assets apart from those that have now been restrained?
No,
So currently, you have no capital whatsoever that you can access to fund to try and start any business, correct?
not to start a business. Sometimes you don't need capital. It's all about ideas.
Ideas.
Yes.
Ideas, how will you manifest these ideas without money? How will you fund?
So you'll contact people with funds, and then you bring ideas on the table.
Oh, it's other
Yeah.
people that will
Other
fund.
people, yes, other business people.
Other people.
Yeah.
Having your assets restrained, all financial institutions, in fact, your bank accounts were already frozen even before your arrest.
That's correct.
Even before your arrest, the banks were unwilling you to access any funds from their accounts. They would also evidently refuse to grant you loans or advance you any financial assistance
Yeah, that time
due
they
to your status.
sorry, that time they only said the account was only frozen for 12 days.
Yes.
Yeah,
But now it's restrained. Now it's frozen
it's
until the
restrained,
case
yes,
is finalized.
that's correct.
So it will be an mission impossible for you to convince the banks or the financial institutions to advance any financial assistance to you in a position where you find your assets being restrained and flagged.
That's correct.
This is more so because the banks are also regulated by Bank of Namibia, which is trying its utmost best for money launderers to not access banking institutions.
But I'm not a money launderer. Those are just allegations for now.
Okay.
Yeah.
So, even if you are released on bail, the status which you find yourself in, where your assets are restrained, it will be mission impossible to start a successful company. You are not sure that any business person would want even to deal with you in a position you find yourself.
But you're just speculating.
Yourself? No, I want you.
I'm telling
Because
you're just speculating.
you are also speculating that there might be business people that might want to assist you.
Yes, put condition, then let me get released, then you will see. Let's not speculate.
Yeah.
Yeah.
Is there any hidden business person that you don't want to mention that is willing to assist you?
No.
Do you have any business person that will assist you now with money to start a business?
To start a business? No.
If you have an idea?
Nice ideas. No ideas are a lot.
No, if you have ideas.
Yes.
You need money to those ideas. Is there any specific business
No, I don't
person?
need money for ideas. I'll just bring ideas on the table.
Yes.
Now share it with that business person.
Do you have any such business person?
Such? No, there are a lot of business persons.
Who?
No, I cannot mention them.
No, you
Yeah,
don't want
no,
to be frank to the court.
No, I want to go victimize them.
Okay.
No.
All right. No, it's fine if you don't want to divulge your business person. But I'll put to you that for a reason that you don't want to divulge them is because they are of no existence. They are not there.
No, Mr. Ipinga, that's not true.
That's not true.
Yeah, that's why I say let's agree on condition, then you'll see. Yeah.
And then, further to that, you also placed emphasis by referring to, it was a divider. Divider 7, my lord. The documents that were marked the B1 thing to B3. Yes.
I'm there.
The first B1 refers to Balarosa ballerina body, body corporate.
Yeah, that's correct.
This property that is listed there is under restraint.
That's correct.
B2, Leo Beer Estate 15. That property is also under restraint.
That's correct.
Is it still on in respect? Oh, you are saying B2.
Yes.
Oh, I see.
B3,
So B1, B2 are all restrained.
restraint, yes.
Okay.
B3, your claim Windhoek property is also under restraint.
That's correct. No Vandaida.
One,
It's not Vandaida.
this one is tonight.
Document what? 110.
Yes,
Yeah.
tonight.
That's Vandaida.
It's under restraint.
Correct.
Yes. Now, what is your understanding with regards to properties that are restrained? Who is supposed to take care of them?
It's a curator.
The curator, yes. So, in terms of section 29 of the POCA, it specifically requires the curator to take care and administer these properties.
Yeah, that's correct. But my wife was given permission to manage the properties with the income from the rental properties. So she's the one who's dealing with that.
How much rental money is being generated from Belarosa Ballerina Body Corporate?
I don't know for now. I need to find out.
You need to find
Yes, yes. And the problem is that some tenants, they don't pay on time. And sometimes those properties, there are no tenants there. That's why you see the things are going into minus and the things are just accumulating.
She chose to
And
manage
some
it.
of- And some, she did not choose. She was given permission by the curators to manage those properties, the income. What she does, she has to give reports every month to the curator. And it's what she has been doing.
She's not paying the bills.
Which bills? Yeah, because the funds are not enough. Yeah.
This permission, she could refuse this permission and say, the curators who have been appointed by the court, who by law are obliged in terms of section 29 to administer and take care of these properties, they should do it. And they should ensure that these things are paid.
The curator also has the power to do that you can manage the property. It's not only done with my wife, it's also done to the other co-accused.
Yes.
Yes.
But my point is, she did that freely. She took that risk freely to administer properties that she cannot care for.
It was between her and the curator. So the curator asked her so that she can manage the properties.
She did so freely.
That's true.
Yes. She's now failing in her duties.
She's being failed by the tenants.
She's failing in her duties.
Not her, the tenants that are paying.
Yes.
They are not paying on time.
Did she ever go back to the curator and say, listen, these properties have been restrained. Take back your property. I'm unable to care for this property and it's your responsibility.
No, there's a report that she always gives.
Did she ever go back
No, I
and
did not.
say,
I did not find out from her. I did not ask her.
yes.
Yeah,
So up until today, she's still the one
that's
administering them.
correct.
So she didn't take them back because the curator, in terms of the law, cannot refuse because this is their obligation and they are appointed by the court to do so.
Oh, okay.
So, in other words, all in all, the outstanding amount here supposed to be the curator's issue. They're supposed to, even if you are released on bail, it remains a primary obligation of the curators to ensure that these bills are paid. Correct?
You're right.
Yes. So even if you are released on bail, it's not as if it will then be your obligations to ensure or to use your own money to put in a property which is restrained by court, by court order.
You're right.
Yes. So that is not a ground. And in any event, by your first bail application, your financial situation was already that you were unable to meet your financial obligations. So that is not a new fact.
But it,
today.
it continues.
You have presented these 3 documents.
Yes,
I
but,
have shown you that that is not your responsibility.
yes, but it continues to deteriorate. It continues.
My learned colleague, I don't know what he's trying to do. He's trying to mislead. The applicant was very clear in that he said that his wife was given permission to manage this property. She writes reports every month.
You are the one that is going back to that, Mr. Siomunji. He had moved on from that question, and there is progress actually between their exchanges.
Indeed, so my lord, but my learned colleague is saying that this is not new. I mean, was this presented at the first bail application? Was
you mean
outstanding amounts there?
You mean the amount or
Yes. Yes, my lord. So my learned colleague is trying to take a blanket approach and just say, this is not new. This was already there as at the, the initial bail application, but he's trying to gloss over these issues of these amounts, the outstanding things and so on, amounts on this property were not there that time. This is new, so he cannot just gloss over it.
Okay, I hear that, but
May it please the court.
how I understand him is to say his financial position was presented before court, and he's even extending it to say that it continues to deteriorate.
Indeed, so my lord.
And to that extent, I'll understand the difference in the amounts of the, should there have been documents presented in the initial bail application, that obviously the amount would be different this time around.
Indeed, so the court is correct, my lord, not the approach of my learned colleague.
But
he's trying to say there's no new facts there. And it shows because that's why initially his view was that we shouldn't have even commenced, the court shouldn't have commenced with bail on new facts. So it shows why he's taking that approach.
Okay, I'll leave it for argument.
May I please the court?
I think he's more on the principle.
May I please the court?
Yes. You may proceed, Mr. Iping.
Maybe just one question to the witness on that
it's
aspect.
fine.
So, when your liberty is taken away by a legitimate court order, it's a natural expectation and a consequence that your financial position will not be the same as when you were having your liberty, when you were allowed to carry on your business.
That's correct.
Correct. Yes. So, the deteriorating financial situation that you are experiencing was an expectation already. It was expected to naturally flow from the order that the court was granting, denying you bail.
But is it now fair to keep an innocent person in custody? That's why I'm here today.
No, that's not where we are at yet. The court will answer that question.
Yeah, that's why I'm here now, for the bail application to prove my innocence.
Yes,
Yes.
but that day when this court gave that order refusing you bail, there was already a natural expectation and an expected consequence that your financial situation will not improve while you are in custody, while it was already in a bad state by then.
But that was not part of the judgment of this court when I was denied bail.
Yes, it's not part of the judgment, but it is something that you have testified about before this court.
Correct.
So it must be that the court, having heard that evidence, though not writing it out in the judgment, must have considered it.
So I brought this fact again to indicate to the court that it continue again. Yeah, it's continuing.
And the rest, having answered those questions, the rest will argue as directed by the court. Emotional support was also one of your emphasis when you say you wanted to be released. In fact, it's your ground number 3 and 5. You're
the
failing
previous
to give emotional support to your children.
Was that now in the previous or?
Oh no, ground number 5. Now, also, similarly to your financial position, when a court makes a legitimate order to deny you bail, the expected natural consequence thereto is that you will not be with your family to give them the love and affection that is expected from the father and from the, is that correct?
Yes, I hear you. That's correct.
Yes. And you went at great length also in your second bail application to advance to the court how you are unable to give this love and affection towards your children.
Yes, because they are protected by the Constitution, Article 14.3. Yeah.
So this was also considered already at your new bail, at your second bail application, even your first bail application, that if denied bail, you will not be able to emotionally support your children.
Correct. No, it was not part of the judgment. As
Yes.
it said, it was not part of the judgment.
The judgment will not contain everything, because then you will have the judgment as long as the record.
Then don't say
But
it was part of the judgment.
But it's something that would have been considered because you did put it before the court.
Yes, I did.
Yes.
But that time, they were still, like my son was not 12 years at that time, he's now turning 12, where he's now entering his stage of his teenage years, where he needs my leadership and guidance. Yeah.
I think just on the issue,
Yes.
I thought the principle is that if one comes back to court on new facts, it must be something new, not dealt with in the initial bail application.
Yes.
Whether new or not is not determined by the judgment that was handed down, but it's determined by what was presented in those proceedings. In other words, if you feel that the judgment is misplaced or overlooked certain things, then you take it on appeal, then probably because it did not take into account what it should have taken into account, and a different outcome would have been arrived at. Because if then we use what is written in the judgment to determine whether tomorrow I come back to court, then it's endless. Is it not so?
Yes, my lord.
Yeah, so I just thought maybe the language of saying it's not in the judgment will not help.
Yes.
Because it's what was presented before court. Yes.
And you now mentioned the age that the person is growing. It's even at that point when you're being denied bail, the expectation is that your children will keep growing. I mean, the years, the months, the days, time will not stop.
Yes, but they need my support, is what I'm saying. As it continues, you're also a father, you know that.
Yes.
Yeah, in that time, that's why I say I've never seen my kids for the past 4 years. I only started receiving visits from my kids this year, January. Yeah.
In fact, your position have greatly improved from where you were when you first brought the second bail application to now, in the sense that, at least since then, your children are able to visit you twice a month.
Yeah, depending on the availability of the facility.
Once or twice a month.
Yeah, once or twice a month.
That is an improvement on your previous position, where completely they couldn't come.
But they still need to be with their father. 1 hour, Mr. Ipinge, you also know that. Even you won't manage.
I understand.
You understand, thank you.
I understand what you are saying.
Thank you. Yeah.
What I'm saying is,
That's why I'm asking for bail to be with my family. Why must an innocent person be kept in prison? That's why I'm here today.
but
I've proved my innocence.
we'll get there.
Okay.
I am saying your position from your previous bail application to now have actually improved in that your children are able to visit you.
That's correct.
Your complaint now is that the facility is not having sufficient places for them to visit. That's why it's limited to only two times.
Oh, it's not the yeah, right.
Yes.
Let me understand this issue. Is it just the children? The wife can visit differently from the children?
That's correct, man.
Oh, okay.
Yeah.
So, did you ever bring an application before court where you are citing the correctional authorities to sue them to make facilities available?
No.
No. You just want to use that in a bail application?
No, those administration where you just engage with the authority. Like what they did, they made time for the kids to come visit you.
Yes.
Yeah, where will I get even money to bring such application?
Okay. And then I want to deal also with ground number 3, that you have not picked up any cases during your 4 years in custody.
That's correct.
Even during your second bail application, there was no complaint from the state, either through evidence or whatsoever, that you had a propensity to commit offenses.
I was not charged with any. I was not charged in any. Ever since I was arrested, my lord, I've never picked up any case.
It has not been the allegation of the state that you must not be given bail because you have this propensity of, if you are granted bail, then you will commit offenses. Is that correct?
I cannot remember.
Yes. It was not one of the grounds of objection.
I cannot remember.
Yes. And being in custody, there is no way you could pick up further cases because as it is now, you have no access to fishing quarters. Your father-in-law is in custody. James is not.
I object. It's disappointing coming from my learned colleague. It's common cause that people pick up cases in custody. Unless my learned colleague is denying that. He cannot say there is no way applicant could have picked up cases in custody because he's in custody. People pick up cases every day while they're in custody. So my learned colleague should withdraw that.
Well, you are right on that. I just thought I don't know whether you were the one who is supposed to be saying it. But it's fine, it's a common cause.
Yes, the applicant might not know, he's a layperson, but the way he's putting it as if it's a fact that nobody in custody can pick up cases, which is misplaced.
Okay, let's see how Mr. Chipinge
My lord,
proceeds.
I'm taking from the indictment for which the accused is before court.
Yes.
The offenses that
He's facing.
is alleged to have committed.
Okay.
It's not something that one would expect to commit in custody.
Okay.
That is what I'm driving at.
Well, maybe you sounded like it was in general terms.
No. The offenses that you are before court for
All right.
are not such that you could commit them in custody. You have no access to fishing quarters.
I never had access to fishing quarters. Yeah.
You have no access to Fishco. Mr. Mike Ngipunywa and James Hatuikulipi, who was the chairperson and the CEO, are in custody. They are not there.
I never had access to those Fishco, whatever was happening at Fishco.
You have no access to the Angolan Minister of Fisheries.
I never had access to the Minister of Fisheries
Yes.
in Angola.
So it could never have been an expectation that if you are kept in custody, you will continue to commit these offenses.
Then I must be released then.
But out there,
My lord, again, there is no, my learned colleague can not say applicant will continue committing offenses. There is no evidence before this court or any court that applicant has ever committed any offense. There's allegations before this court. So my learned colleague cannot say you continue committing offenses. You should withdraw that.
Well, I think on the principle you are right. It's just that I understood it in a different way. What did you
I'm going
place
with
on
the
the
ground
record?
of appeal, of the ground of the new fact, the purported new fact.
Yes.
Yes, to say, look, even from the second bail application, there were no offenses committed. It was not the state's view that you have propensity to commit these offenses in custody.
Yes.
You have no access, and you cannot access the tools to commit these offenses whilst you are in custody. Because
Yes, I understand that.
yes,
Mr.
based
Simon.
on the indictment that he's indicted
Okay.
to answer to before this court.
Mr. Siomunji?
May it please the court. My lord, what we were objecting to, my learned colleague has cleverly, in a very clever way, has changed his words.
Okay.
What he placed before court was that applicant will have no capacity to continue committing offenses. Those are the words that he used on record.
Okay.
And that's what we objected to.
All right,
And that's
I
why we said that there is no evidence before this court or any other court that applicant has ever committed any offense.
Okay.
But there's allegations.
Well noted.
May it please the court.
That's in order. Thank you. Mr. Ipinge, you'll proceed. Yes. Yes, please.
Okay.
Anytime.
Okay, sir.
While he's going through his documents, I wanted to find out regarding this divider 7. Is it only the property under Belarosa that is being rented out, or the others also?
Others also, my lord.
The others also.
Yes, my lord.
Now we deal with your ground number 6. And with that, you started off with documents that you have presented as marked as B5.
Document what now?
This is document 2. And before your bail, your second bail application, you obviously had Johannes Steffenson's affidavit already.
Before
Yes.
or on my bail? No,
Before
no.
your second bail application.
Yes, yes, yes. Only on the first one. First bail application, I never had it.
Yeah, the second.
Only on the second.
Is it the affidavit?
Yes. It was actually presented by the state for purposes of that second bail application.
It was not part of the first bail application.
It was not provided to me, my lord.
No, the affidavit was provided to court even in the first bail
No, no,
application.
they did not. They were just referring that there's a statement from a reliable witness. That's all what they've been saying.
I thought it's there.
In the first one,
Yes.
in the magistrate.
It's
It's at the magistrate, my lord. It's talking about the first
no,
one.
no, no, no. I cannot comment on
No,
that.
yeah, no, it was
Yeah, I
not. On the
cannot
second,
comment.
yes, at the
For
High
the
Court.
in
Yes,
the High
yes.
Court.
Yes.
Okay.
There it was.
The second bail, yes.
Okay. No, I understand.
Now, having regard to that, and also in the second bail application, you remember Willie Human's statement was also presented before the court.
That's correct.
Correct. And From Stephanson's evidence or affidavit, as well as that of Willie Women, what comes out there is that even before they approached you, they had approached several other people to try and access fishing quarters in Namibia. That is now Samherji.
In Stephenson affidavit. Is it there?
Yes.
Page?
So there's you are referring to Willie Human.
Willie Women.
Okay.
That's Stephenson's affidavit. No, sorry. The testimony of Mr. Kanyangela before this court. Sorry. In your initial bail application.
So not Johannes. So
Yes.
Mr. Kanyangela. Oh, okay.
Yes. Was always that before they go to you, they approach several other people, such as Petrus Nehoya,
That's correct.
Willie Human.
That's correct.
Now you have now added Harold Butkevitz.
That's correct.
So already in your second bail application, it was no dispute that Samherji have tried to access fishing quarters in Namibia through other people. Correct?
Correct, but you were alleging, you were saying that I was the link to the minister. I was the link between Samherji and the minister. So the reason why I brought this document before is to show to the court that the people who link the minister to Samherji are these people. That's the reason why I brought the document, Mr. Ipine.
From these documents, B5, B6,
I don't have them in B. If you just can say document.
oh,
Yeah,
sorry,
I do not mark them. Sorry, madam.
Yes,
No, it's fine.
Yeah.
because unfortunately the exhibits are the ones that I was referring to. But,
Yeah.
by the request of the
Yes, it's fine.
accused,
You can also
the applicant, I can
the
refer
page
them.
numbers, I think, because it looks like each document has a numbering in a black marker on the top right. It can also help.
Document number 2.
Okay. Okay.
There is nothing in that communication that shows that in actual fact, Samherji, Johannes Stephenson, and his colleagues were able to meet the Minister of Fisheries through Mr. Harold Popkewitz. There's nothing there.
So document 2 is exhibit what?
Exhibit B5.
B5.
Document 2, if you go. What was the question? Sorry, repeat your question, Mr. Ipine.
There's nothing
Uh-huh.
that shows that in actual fact, they met the minister as organized by Harold Popkewitz.
I would not know, but the documents are clear. Yeah, the documents are clear. I cannot speak for the document, but they are clear. If you'll go at page 3 of 4, here, 31 October. So Johannes is writing to Mr. Harold Popkewitz. The plane will, if you go, now it looks like that we will arrive on Sunday on the 6th of Windhoek, and the plan is we will have a meeting on Monday with the minister. So he's now writing to Mr. Popkewitz.
They were planning.
Correct.
It was prior.
Correct.
After these emails, after the 8th, there is nothing to show that indeed they met the minister on the 8th as organized by Harold Popkewitz.
I will not know, but the document, they speak for themselves, that they were engaging the minister.
You brought this document.
Correct, it's your documents.
Yes.
Yes.
Now I'm saying, from reading this document, yes, there's a planning to meet the minister.
That's correct.
There is no confirmation that Samherji indeed, or the plans worked out for them to meet the minister.
It's a confirmation on document 1, the letter from Mr. Popkevets to the minister.
Where does it say that they have met?
You just read the whole document. As I read over now, the whole document.
Show us where it says they have met. That's what I'm driving at.
If you go to where it say here, okay, let me just read the whole thing. Dear Honorable Minister, about a week ago I received a telephone call from Mr. Daniel Levin, with whom I have a friendly relationship since many years. He's a lawyer of the highest repute, and he has and had his office in New York until recently, when he gave up practicing law because of his other commitment, amongst the foremost of which the many years relationship with the government of Iceland as an agent consultant. Secondly, he holds a similar position in a relationship with the Principality of the Liechtenstein. He requested my intervention with your good self to give a fair hearing to Cutler Company, whose company include fishing, processing and marketing of fishing. So here is requesting his intervention, which means, okay, let's continue. And Cutler Seafood Company is represented by Mr. Johannes Stephenson, Adelstein and Ingwa Juliusen, whom, as you perhaps already known, intend establish, whom, as you perhaps already known. Through whom now? How did they meet? Okay. And intend establishing a factory in Walvis Bay on the strength of being successful in receiving a yearly fishing quota for horse mackerel. So he's asking the minister now. They can give a yearly quota to horse mackerel to Samherji. Without my intervention, I'm not even part of it. The Icelanders, as I know them, are highly progressive and productive, reliable people and ethical in the conduct of business. This request I will not make if what? If we're not confident that it will redound to the benefit of Namibia, not least result considerably in job creation. Many thanks for giving this matter for your kind consideration. Harold Popkevets.
Yes. It doesn't say they have met.
Who now? Who did not meet now?
The Samherji representatives and the minister. This was still a request for them to meet.
But he said whom perhaps you already met.
No.
But the documents here say they met most. They were meeting the minister. When was it?
Show us where it says that they have met.
Which year was that?
It was 2011, my lord.
2011.
Yes, my lord.
But it was before
His
his involvement.
Correct,
Yes.
correct, my lord.
Okay.
But then you were not the son-in-law yet.
How do you know? When did I get married? I got married on the 8th of October, my lord. 2011.
2011.
You were not
Yes.
introduced to them by then.
Okay, my lord, if you look at page 3 of 4, we'll arrive on Tuesday morning on the 8th of November. We have a meeting with the Minister of Fishery on the 9th of November, Wednesday.
Who was writing that email?
This one is from Johannes Stephenson, my lord.
Okay.
Yeah, writing to Mr. Harold Popkevets. Yeah.
So what you are saying is the emails or those documents show that Samherji had met the minister before your involvement.
That's correct, my lord.
Okay.
The what? Sorry.
Yes, it's fine.
What I missed that, the specific, is it document number that you just referred to?
3 or 4
3,
on top there.
document 3.
Document 2, 3 or 4, page 3 or 4. On top there. Are you there?
Yes.
Yeah,
It says potential meeting.
correct? And when do we are? Confidential.
Again, that's my previous question. This was a planning for a meeting. There is no email here that says, yes, we have now met the minister. This is the outcome.
Yes, you are right. My point is that I'm not the link to the minister, as you have been alleging.
You are,
So-
this does not prove that they were the link.
So they met us.
My colleague should be courteous at all times.
Okay.
If he may be allowed to finish.
All right, that's fine. You want to add
No,
something?
I was just trying to, yeah, I'm done, my lord.
Okay. Mr. Ipinge?
That's why it is stated, even through Mr. Kanyangela's evidence. The meeting was apparently planned for the 8th and the 9th of November.
Correct.
Document number 1, the letter, was issued on the 14th of November 2011,
That's correct.
some 5 days, 5 days thereafter.
That's correct.
Yet, the letter of 6 days after does not confirm
That's why Mr. Popkevich,
that there was a meeting with the minister. He's asking. He's still asking.
that's why he's saying.
For him to give a hearing to them. So there was no hearing. He's still asking, please give Cutler a hearing.
That's why he's saying who, as you perhaps already know. How does he know them? How does he know that he knows these people? How does he know that the minister knows Cutler?
Thank you.
So, my lord, the letter will speak for itself, my lord. It's before court. Let us not waste the court's time on documents that are clear.
And according to you, this Harold Popkevich did fail to ensure that Samherji would access fishing quotas in Namibia, correct?
That's correct. They did not manage
They didn't manage.
all the people that were assisting Samherji.
Willie Yume also did not manage.
That's correct.
Yes. But what comes out
Is that a Namibian or is part of Samherji?
is a Namibian.
Okay.
The statement is before your lordship in the
Yeah.
previous bail application. But what comes out of these emails is Samherji's drive to meet the Minister of Fisheries, correct? They so wanted to get close to the minister.
That's correct. And they did.
Can you see? No.
Oh, so.
Here.
No, I thought you were done.
I'm just talking about their drive. They really wanted to meet the minister. Yes. Now, if we go to how the fishing quotas were working, there is an operator. The operator have a relationship with a right holder who may be awarded quotas by the minister.
Who could be an operator?
Operator like Samherji,
Oh, okay.
right? They try to get right holders. Those are the people that they will form relationships through catching agreements. Correct?
Correct.
Yes. The right holder will have a relationship with the Ministry of Fisheries because they are awarded these rights by the Minister of Fisheries,
The Ministry of Fisheries.
by the Minister,
Oh, okay, if you say so. Okay.
correct? Yes.
Is it the minister or is it the PS that awards those quotas?
The Act says the Minister.
Or the Act? Oh, okay.
So there is not necessarily a need for a relationship to be between the operator, who is Samherji, and the Minister of Fisheries, because the Minister of Fisheries can never give them quotas directly. Can only give them quotas to a right holder, and those are the people that they should meet, correct? Not the Minister.
Correct. To enter into a catching agreement.
To enter into a catching
That's
agreement.
correct.
Yeah.
Because Samherji is not a right holder. You are right?
Yes. So their drive to meet the minister was just to corrupt the whole process.
So it's now them and Pupkewitz and William and Daniel, no?
No, Samherji's intentions.
And who now? And these people now?
No.
The Harold Pupkewitz and...
I'll demonstrate to you how.
Okay, you can continue.
Yes. So Samherji's drive, knowing well that they needed to access the right holders, not the minister, but they so wanted the minister, was because they wanted to corrupt him as they did in the end through you.
No. I disagree with that.
I'll keep standing up to object as long as my learned colleague makes sensational statements.
Okay.
There is no evidence before this court or any court that the applicant, or participated in any corrupt activities. It is an allegations and remain as such.
Yes.
My learned colleague should confine himself to that. I'm mentioning it for the 18th time that whatever the applicant faces are allegations. My learned colleague should know better.
Thank you, Mr.
May I please the
Samherji.
court?
Mr. Ipinge, can you just address this issue?
Yes.
Do you agree with your colleague then?
My lord,
Well, in this case,
when
Yes.
okay, when there are allegations, we have time and again proven that the state have a strong prima facie case against the accused. Time and again. We have disclosure and we have read. We are convinced, as the state, that corrupt activities were committed. I'm not entirely out of line to state our position as we represent it. Perhaps they wanted to sugarcoat this as just mere allegations. No, these are allegations that we have time and again proven to have a prima facie case.
well, I understand that. I think quite a lot happened,
Yes.
and it's clear from evidence that has been presented before court. Only that when you say it in general terms like that, to say until either you got involved in these corrupt activities, it may not be very clear as to which involvement are you referring to. Let's say in this case, he is saying, when you were asking your question, he was saying, are you referring to Samherji and the likes of Pupkevis and Willie Human as the ones involved in corruption as when they tried to meet the minister? Then you said, I'll demonstrate to you. And then that's when you went then to say, until he got, if I understood you well, until he got involved in these corrupt activities. But now it wasn't clear. Is it his engagement with Samherji, introducing them to the fishing industry in Namibia, or what? So if you could be specific so that he can also be able to know what you are referring to and deal with that. I thought that could help.
As the court please says,
Yes.
I stand guided.
So, well,
indebted to the court.
it's fine if you say this and this amounts to corruption which you were involved in. I don't think the court can stop you from doing that, but at least he will know what allegation he's facing.
As the court please says.
Yes.
Now, from there, we have dealt with the Pupkewitz issues.
Maybe before that,
Yes.
from the angle you were asking this question, I don't know if you are in a position to answer this question. It does not really relate to you. He's saying that in terms of the setup of the law, there is no need for the minister to be, or the operator to be involved with the minister. So what Samherji was trying to do here in wanting to meet the minister was to corrupt the minister, or to corrupt the whole setup. You agreed with the question.
No, I will not comment
No,
on
the
such
earlier
things,
question that he had
because that
asked.
is now between Pupkewitz
Okay.
and Willie Human and Danny Levy, that they are communicating about meeting the minister, and I'm not involved, my lord.
Okay.
Yeah, if the state can just prove to the court where did I corrupt or what action did I took in any criminal syndicate is they are alleging, my lord. If they can prove that, then it's fine. Then we can deal with it.
Yes. Maybe.
Mr. Ipinge, you are not the one who is answering the questions.
Yes,
you
I'm
are
not.
asking the questions, but I see you going backwards when he wants to assert that from the way you are asking or you are dealing with this issue, by implication it means that whoever was arranging between Samherji to meet the minister
Yes.
was involved in corruption. But then you seem to say, well, I'll demonstrate. You will only demonstrate his involvement.
no.
Maybe unless you are saying that their involvement was different.
No, my lord, I'm saying that some were acting as conduits
Okay.
to get Samherji to the minister,
Yes.
so that Samherji can corrupt the minister. That does not mean the middle person would also partake in the corrupting of the minister. They get him there.
At least I understand now. If you say it like
Yes.
that. Yes.
They get Samherji to the minister. Samherji does what he does to corrupt the minister.
Okay.
Yes.
Okay.
No, so I take out the middle part because
Okay.
there is no evidence that they ever succeeded to get there, to get Samherji to the minister, so that Samherji will have an opportunity to do what they had a big drive. And that's why I started off that Samherji had this big drive to get to the minister even before getting to the right holders.
I understand.
Yes.
Thank you, sir.
So, and because they had consulted so many people, and it proved futile, that's how you were introduced. It came to your introduction that perhaps the new son-in-law will be able to take you to the minister. And that is exactly why you showed your photographs at this first meeting, to prove, as Johannes says, that you are who you claim to be.
That's why I'm saying I was not the one who introduced Samherji to the minister. And the minister, during his bail application on new fact, he clarified on that. He was introduced by someone from the ministry or whoever, or someone from the industry. That was put on record before this court.
Who said that?
The former minister, Mr. Bernard Essa, during his bail application on new fact,
Okay.
that
What
was
did he say?
introduced by Samherji by someone else from the industry.
Okay.
Yeah, it is on record. And Mr. Marondeze was before this court when the former minister testified. I think Mr. Marondeze must help Mr. Ipinge on that.
Right. Now, my lord, we are not going to reinvent the wheel. Previously, we had put a bundle before court.
Yes.
I hope the court still have bundles
Yeah, the bundles are with the court.
with the court, yes. Does that want to do with one aspect?
My lord, I do
Okay,
not
Mr.
have
Seo.
whatever bundles my learned colleague is talking about. So if he wants to refer to any documentation in whatever bundles where I was not involved, must provide copies of those bundles so that I'll be able to duly follow.
Oh, yes. I have a copy. Sir, and for the record, you are not put before Samherji.
I was not. Repeat
You
your
have not put anything before the court to say that when you presented yourself to Samherji, you presented yourself to be in the fishing industry, correct?
I never presented, sorry?
You have not put anything before this court to show that when you met the people from Samherji, you at least indicated that you were somewhat involved in the fishing industry of Namibia.
No, I was never involved in the fishing industry.
Yes.
Neither the right holders were involved in the fishing industry before.
Yes.
Yeah.
So, at least by then, the only connection and relationship that you had to the Ministry of Justice is its leadership. The minister was your father-in-law. That was the only thing that brought you close to minister.
My lord, where
My previous bail application. We dealt with it and I told you I was not the link.
my lord, my learned colleague can clarify. He mentioned Ministry of Justice.
Yes.
Does Ministry of Justice have anything to do with this case?
Minister of Fisheries, you, the closest thing you were to the industry, the fisheries industry. The only relationship that you had by November when you met people from Samherji was that you are the son-in-law of the Minister of Fisheries and Marine Resources.
It does not say so in my agreement, my lord. I have agreements that are in place.
I'm not asking you about your agreements. I'm asking you about your relationship with the industry before and on the first day of meeting the Samherji people.
No, I was not in the fishing industry.
Yes.
Yes.
You confirm with me that your only link, yes, your only relationship was with the minister.
No, I disagree with that.
You didn't have a relationship with the minister.
My lord, the documents are clear. What was happening from 2012 up to 2018 between myself and Samherji. These emails are clear, my lord.
Yes.
And you
I
don't
think
see
I've-
the minister involved in this document.
I think I have
Yeah. Documents are clear,
asked
my lord.
that question sufficient times.
The witness can be allowed to finish before Mr. Ipinge just keeps chipping in and, disturbing him. If he may be allowed to finish what he's saying.
Well, Mr. Ipinge, just kindly do that to allow him to finish his answer. But also, Mr. Hatuikulipi, it will be helpful to your case to refer to the evidence. Because you are just saying the documents show,
okay.
they show what? At least
Okay.
also say what they show. Because now the court will not understand what is it that the documents show.
Oh, okay, my lord. Okay, my lord.
Because I understand the question to be that there was the only thing that linked you was the Minister of Fisheries. You were not involved in the fishing industry. That is the question. And you are saying the evidence show or the documents show otherwise.
I hear you, my
Yes.
lord. Like document 7? It's clear, my lord. It's from Johannes Stephenson, sent to me, group contact. If you go to,
Was that before you introduced Samherji to, before you met with Samherji at the hotel?
no, this is now after, my lord.
Your question was relevant at what stage, Mr. Ipinge?
Before meeting Samherji.
Yes, I think. So you are answering in respect to what happened after.
That's correct,
After
my lord.
meeting.
that my involvement with Samherji was all about getting the JVs on board, my lord. Yeah, that's why I was now referring to this document where Johannes is now.
Okay.
Yeah.
It's quite an important aspect. Mr. Ipinge,
Yes.
can you, in fairness, just repeat what you were trying to put to him so that I can gauge how he deals with the issue? Yes.
My issue is, these are people that were trying to get into the fishing industry, to access quotas. The emails that you have produced, number 5 and number 6, shows their drive that they needed to get to the minister.
That's correct.
You have no experience whatsoever in the fishing industry
That's correct.
before meeting them.
That's correct.
Right.
That's correct.
But of significance, you had a relationship with the Minister of Fisheries and Marine Resources that, according to the documents, they had such a high drive to meet.
Family relationship, right?
Yes.
Okay.
Is that correct?
Yes.
Yes.
Family relationship.
And that is why, even on the day of your introduction, you had to prove that you are who you claim to be by showing your wedding pictures of you marrying the daughter of the Minister of Fisheries.
No, I did not.
Yes.
No, they.
That is
No,
what
no,
I
no.
wanted to canvass.
No. I was not, when they met me, I did not even mention that I'm the son-in-law of the minister. They brought it up themselves. And the person that introduced me is the one who mentioned that to them. Then they asked for the picture of my wedding. I asked them, how do you know I'm married? That's how we got to that picture. And then they say they want to see the picture.
Now, I'll show you that even the memorandum of understanding that you signed for the first time, it had to get some blessing and approvals from the Minister of Fisheries.
I disagree with that, my lord.
Okay.
Disagree with that.
My Lord, if we can go to, previously it was marked as Exhibit D. I don't know if the court has its bundle.
Not the other bundles in the previous
There.
bail application, but you can, if you want to refer
Yes.
to.
Maybe I can.
I just want to ascertain, is it the document that the bundle that my learned colleague just gave?
Yes.
Okay.
And in a fairness, is there a copy also for the applicant so that he can follow? Because whatever it is that my learned colleague intends to use, surely all parties must be given copies.
Well, it's fine. That's fine. You are right.
May I
there.
please the court?
If you are to refer to a document, then you will give it to him. Either you can give yours to him, then you ask a question. At least when he's answering, he can see the document you are referring to.
Because I labored under the impression, because these are things that we had already previously given a copy to the accused, to his lawyers. We had also given a copy to the court. Now I came with 3 copies.
Yeah.
Just for this unexpected issue, but these are documents
It's
that
part of the record, so to say.
yes, documents that I have already provided before.
Yes. It's just that in any case, Mr. Ipinge,
Okay. Yes. Perhaps I can just show him documents.
yes, I think that
for him
will
to
work.
follow. But for the court to follow, because I need the court to follow.
No, it's fine.
Can that not go to the court? Or should that go to the court? Or
You know, I record the questions and answers, and as long as you identify the document, I can even, because they are already part of the,
part of,
yes, the record.
Thank you, my lord. So let us go to, you will see in that bundle, on top there are numbers that I have circled, written in pen.
Yeah.
Go to number 6.
Number 6 on there.
It says, Namibia situation, because there is now an email from Adelstein Hagelsen to Johannes and Ingvar.
Yeah, I see them.
Yes. Now, the third line says that the purpose of the meeting, okay, the subject is Samherji, subject Namibia situation, greetings, Adolfstein, situation, meeting today at 1200 hours with 3 persons from this 6 JV.
Okay.
The purpose of the meeting is, as we understand, to follow up on their decision to work with us. Hear from us how we propose to work this out. What is in it for them, etc. The intention is to complete signing the MOU with 6 JV on Monday, but they need to get their papers issued in order. This could become JV7.
Okay.
JV7 is the name? Epango?
Just say it could become 7 JV.
Yeah, 7
Yeah,
JV.
it does not say JV, it's a 7 JV.
We complete the MOU today with Tamson. Emphasis the son-in-law. It will be taken to the minister tomorrow. The intention is to finish the letter of intent for Hague today. The first person could then receive it today. And then it comes in the coming days. Looking at other quarters. The emphasis is, when
Just
did you
continue.
complete?
Just continue.
Yeah. Looking at quarters,
what?
John Rousseau could have 2 existing quarters. Best regards, Johannes.
Okay.
Right.
Let's identify it. You said it was handed in as exhibit.
D7 previously. First and foremost, when this document was, when you were given a chance in your second bail application, because it was produced by the state, for you to comment, you refused to comment on this document, correct?
That's correct.
So this is something that you already had an opportunity to provide if you so wanted.
No, I comment, I say I never took any MOU to the minister. Yeah, no, I did comment. I recall very well. Say I never took any MOU to the minister. Yeah.
But what is clear
My
from...
Lord, I think before my learned colleague moves on, this is very important. If one alleges that applicant refused to comment, and he is saying he did comment, and he said that he never took any MOU, it must be established, because one cannot put any incorrect position to the applicant. If my learned colleague is alleging that the applicant refused to comment, let him show on the record, that part of the record where this document, D7 in the previous bail application, was put to the applicant and where he refused to comment. Otherwise, he must withdraw that. May I please the court?
Mr. Iping.
Presented in the bail application of the former minister. It was also asked the same question. Then he said he never received any MOU from me.
Doesn't matter, my Lord. We will argue with the record.
It does.
My Lord.
The minister in his bail application, he was asked the same. Then he said he never received any MOU from me.
My Lord, it's very important. It does. My learned colleague has a habit of, when he's challenged on things, he just wants to say it doesn't matter. It matters. We must put correct facts to the applicant.
Okay. Where are we now? Is it not that he has then refuted the question that was asked? In other words, initially it was asked that you had not said anything about this D7. Then he's saying, I said the following. Then if he does not show the record, then it means he has refuted that allegation.
Yes, my Lord, but my issue, Your Lordship, with respect is what is being put. Because one must be very sure. As a legal practitioner, don't mislead.
I agree with that.
You see, so if you are sure that indeed on a particular point in the previous bail application, the applicant refused as was put, then you must show. You refused on page so and so, this is what was put, you refused. So it cannot be put to him incorrectly. If he didn't refuse, then what is the purpose of misleading?
Okay. That's fine, Mr. Siomonji.
May it please the court.
It's fine, my lord. We'll deal with the email as it is, and we'll ask directly the questions from the email. So, here it says that you completed the MOU on that day. Is that the day that you completed your first MOU?
I don't have the MOU now. It should be, yeah, I think it's the same day, 17 December. Yes. The same day, my lord.
Indeed. It's the same day of the 17th of December 2011.
Correct.
Yes. And the day that you signed the MOU, the only title that you were given by these Samherji officials was not that of being a consultant, an external consultant for Samherji. The title that you were given was Tamson, the son-in-law.
I see that, but
Can you see that?
on the MOU, it says the agreement is between Samherji, SCMR Fishing, and Tamson in bracket as the partner. Do you have the MOU with you there?
Yes.
Can I have a look at it?
You referred to what? To the heading?
The MOU,
The sub, okay,
the MOU,
yes.
it says it's between SCMR Fishing here in after called Katla and Tamson Hatuikulipi, PO Box 9083 here in after called partner. It does not say son-in-law. And the funny thing about this email, my lord, it's coming from Adelston. And when we signed this agreement, it was me and Johannes. And here it says from Adelston to Johannes. So it gives a big question mark on this thing.
Why? Why? Maybe comment. What do you mean? What is the issue if it comes from the other
this one, when
person?
we signed it, it was between Johannes and myself. We are the one who signed
Was
it.
Johannes not working with the other person?
No, he was working with Adelston. But the email is coming now from Adelston to Johannes.
To Johannes?
Yeah, it's not from Johannes to Adelston.
Okay.
Because Johannes is the one must brief Adelston. Because Adelston was not there. Now it's Adelston briefing Johannes.
Okay.
And what about Ingva?
Ingwa, when we signed, it was also not, it was just Johannes.
Exactly.
Yeah.
But this
But
email,
the point I'm trying to make, it's
this
coming
email is also going to Ingwa.
I'm talking
Can
about
the
where it's coming from.
applicant be allowed to answer the question?
Yes, sustained, Mr.
May
Siomonji.
it please the court.
So the agreement does not say son-in-law.
Just on your previous point, this email is also sent to Ingva.
I see that.
Yes.
But you agree with me that this email is from Mr. Adelston.
Yes.
Now I'm telling you, he was not there when you signed the agreement. You agree with me?
But he
Now
was there
Mr.
during the negotiations.
No. Now, Mr. Adelston is the one who is now informing Johannes and Ingo. Where did he get the information from?
When you met the people from
No, I'm talking about the MOU, when you signed the MOU. And there's a time Mr. Adelston left and Johannes was the only one that was left.
So what could it mean if it's like that? You are questioning it rightly to say, well, I'm signing this MOU with Stephenson. But now it's Adelston who is sending the email to Stephenson.
Stephenson, yes?
Yes. What do you make of that?
This information is misleading. It's not right.
Oh, okay.
It's not right, my lord.
All right.
Yeah, that's why I say I never took an MOU to the minister.
Who were the people that you started negotiating
Negotiating.
with the Samherji people? Who
The
were
people, no, you must say the people that I met,
they? The people that you met, who are
that
they?
I was introduced to. It was Joanna Stephenson, Ingwa, and Adelston.
Adelston.
Correct,
Adelston, the same person who is writing this email.
correct.
Yes. And Adelston and Johannes were both working for Samherji or Katla.
No, Adelston was Joanna's superior,
Superior,
if I
yes.
might put it that way.
What about Ingva?
Ingwa was a financial guy.
Yes.
Yeah,
So Johannes reports to Adelston himself. Is that what you're saying? It was his,
No,
his
no, let
superior.
me- of course he was the top guy when we met.
He was the
Yeah,
top
yeah,
guy.
he was the top guy.
Yes.
Yeah.
And Ingva, the financial person, also had to be updated.
It's copied, it's also sent to him, yes? That's what
Yeah.
it said?
So there is nothing strange if Mr. Johannes, before this email was then written, had communicated to his superior, Mr. Adelston. There is nothing strange to CC him in or to send it to him when he is briefing other persons, such as the financial manager, Mr. Ingva.
Okay, now I'm saying I never took
There is
any.
nothing strange.
Yeah, there is nothing. That's what I'm saying. I never took an MOU. That's what I'm saying.
Yes.
Okay, thank you.
I'll go to page 507 of the record of the previous bail application. Yes. I'll read to you.
500? $500?
My lord,
Yes.
My lord, to page number 7 of the. Oh, sorry.
I just wanted to ask if Mr. Ipinge is still taking instructions. Because he's holding the court.
What does he think
once
Mr. Marondeze is here for when I say he
adjournment.
came to assist? What does he think he's here for? I introduced Mr. Marondeze to say he's here to assist me. Thank you.
You may proceed.
Go to page number 7.
Number?
7.
And there?
Page 7 of what?
Of the same document.
Okay.
It says, "Greetings, Adelston. See attached MOU which will be signed with Tamson, the son-in-law. We attach the document to show what could be on offer, but we say that we could also negotiate other terms. He will take this to the minister who will receive this tomorrow. The underlying idea is that he should be assured that he will get something if he brings something to us. If you have comments, then let me know. Best regards, Johannes." Right. So now, this is the reason we are taking it to the minister. You must be assured, he must be assured that you will get something from this deal.
Now, what is that something? I may ask. That's why I say I never took
I
any
was
document.
not there. You tell us, what was that something?
There was nothing, my lord. Oh, that's why, my lord, if you look at...
My lord, so this is an email. Unless my learned colleague is able to bring the author of this email to be able to explain what was meant there, even he himself will not know what this something is. unless it was spelled out in this email. So he can assume, but that would be misleading.
No, I understand that.
Yes.
You are quite right about that. I thought he's asking the applicant who was part of this.
My lord, this email, the applicant is not part of this email. It's only that...
The MOU, he's saying he signed the MOU with Stefansson. And
Indeed
the
so.
emails pertain to the MOU. So
Indeed
to
so, my
the
lord.
extent he's able to assist the court, I think he can... he should be allowed to assist the court. Where he's not able to, then he can indicate.
Yes, my lord, but the only issue I have is your lordship now is not following because you don't have this email.
No, it's fine, but I can hear the content.
Yes, my lord, but if your lordship had it, you would see that, first of all, the applicant is not copied in this email. Okay. This is an email from Johannes Stefansson to his people that he's working with. It's not copied to the applicant. So whatever is mentioned here, whatever it is pertaining to that the applicant should get something, he's not part of it. And my learned colleague is asking the applicant to explain, what is this something? And he said, he doesn't know. What is this something?
So you are saying he answered that question to
Indeed,
say
so my lord,
know.
and he's being pressed that he should explain. How should he explain something which he was not party to, it's not copied to him? And that's why I said, then the author of this email should be the one who should explain what he meant by that something.
Oh, okay.
My learned colleague cannot take it further than that, and he knows it.
All right.
May it please the court.
Mr. Ipinge?
You see, now that's where we go to page 507 of the record. When I was asking you in your initial bail application to comment on this issue, line number 20, it says, at page 7, it also an email from Johannes Stefansson to Adelsteen that you testified about in Ingvar. Do you see that? Your comment was as follows.
I don't see it. I don't have the record.
Yes. I'm reading to you.
Okay.
No, I'm reading to you the question.
Oh, okay.
The question was, do you see that? Your response was that, my lord, I have no knowledge of this email. My lord, this document. I'm not the author of this document. I was never part of this communication, my lord, so I cannot answer to this document. You remember that?
That will still be my answer. I have no knowledge. That's why I'm asking you, what is the something? Maybe you know. And you maybe can prove it to the court. This was the something that was being referred to. If you can do that, what is that something that they are talking about? Because I have no knowledge of this document.
So what you are saying is that while is it the emails or the memorandum, the MOU, which says he will take it to the minister? Which
The
says
email says
email,
the memorandum.
So you are saying that you never took the MOU
I
to
never
the...
took, and I'm also not, I don't even have knowledge of this email, my lord.
Okay.
Yeah. And if you look at even this email, my lord, if you look at it, it's not for me to comment, but if you look at it, the one for 7, document 7, it says the time that was sent, it was 12:45 p.m. And the one for Adelsteen, document 6, it was sent 9:50, the same day. Which one was sent first? Is the one for Adelsteen?
Do we use the same time in Iceland and in Namibia?
When it says AM, I'm just referring to the code. Does it say Iceland time?
Do we use the same time in Iceland and in
No, we
Namibia?
don't.
Good.
So I have no knowledge of this document, my lord. If Mr. Ipinge can just prove to the court what is that something that is being referred here, then he must
That
prove
is
it
not
to
the
the
point.
court.
That is not the point, Mr. Hatuikulipi. My point is, whether you are getting something or not, that is not the point. The point is the MOU will be signed with the son-in-law and it will be taken to the minister. So according to these persons who you negotiated the MOU with, it was of great importance that the MOU that they sign with you reaches the minister to assure him that you will get something from this.
And Johannes have lied to his superior.
Johannes
Now
lied.
he lied to his superior. Then I'm telling you, I never did that. Yeah, he was lying to his superior.
And then I'll go
My
on.
lord, I just want to place it on record. My learned colleague cannot raise something and then later on say it is not of importance. The fact that he raised it shows that it is of importance, because the emphasis initially was on the issue of the something that he read, that was in that email, and he asked the applicant, you must tell us what is that something. And the applicant indicated, Your Lordship, that he doesn't know. Maybe Mr. Ipinge himself knows who is raising it. And that is why I indicated that the danger of relying on an email of which applicant was not copied in that email. So the author of the email is the one who should explain that.
Well, thank you. That was clarified, and that became part of it. But the question is, was the MOU being taken to the minister by the applicant, which he said he was never aware of these emails, and he also did not take any MOU to the minister. It started from then, and then that's when he went on to read the portion of it seems the Samherji. It was quite important for them to have the assurance and that there will be something sort of in return. So it just became part of the question.
Yes, but it's an integral part of it. And the one who is introducing the email is the same Mr. Ipinge must. Maybe explain to the court, or if he has some evidence, was this MOU taken as per this email that is introduced? Does he have evidence that it was taken?
Wants to cross-examine me.
No.
Yeah.
You cannot introduce a thing and just keep it hanging there, my lord. If you are introducing it and you are alleging that because the applicant was the son-in-law of the former minister, and because the email says from the author that the MOU will be taken to the minister, then you must complete it. Was it taken?
Well,
do you have such evidence?
It's fine, Mr. Siomunji. Those issues have been canvassed. He's answering the questions. I tend to feel that he had to ask the question because it's there in the email. How he answers it will help the court, and he has distanced himself from the emails. But the emails remain part of the record, or they were sent.
Yes.
So that is the reason why they are being asked.
May I please the court?
Yes.
And of significance, the reason I want to tell you, the reason that it was so important for the minister to be involved is because he was also playing his part to convince the JVs to sign up with Katla or Samherji group of companies. What is your comment?
I disagree on that, my lord. I'm not aware of any JV that was convinced by the minister. If there was one, I'm not aware, my lord.
Yes. In fact, that was one of the strategies that you were using, especially James, to convince these JVs that if you sign up with Katla, the minister will be appeased.
Repeat your question.
It was one of the biggest strategies that James was using to convince these JVs that if you sign up with Samherji, the minister will be appeased.
Oh, you say James, not me. Maybe that was his strategy.
You employed James, you say?
Yes, I asked him to assist me. That's true. Yeah, but if whatever I went to go discuss with the JVs, I was not present. Yeah.
Okay. So again, and that is exactly what comes out at page 13 of that email bundle. Page 13.
Yeah.
Okay. The second paragraph. That's the one now. Because these emails are before court, I don't want to, my lord, like we did the previous bail application where we were going through all the emails. I don't want that.
Yes.
I'm just concentrating on exactly the portion
That's fine.
that I want to say that I spoke to Sharon just now, and she says we should wait. She has people in there that she trusts and could possibly explain to them the advantages of working with us, i.e., Tamson, James, and Saki.
I see.
Yes. And the advantage is now there. It says, that is to say that the possibilities of additional quotas are greater with Cutler than others.
Again, my lord, I don't have any knowledge of this document. It's between Johannes, Adelston, and Ingwa.
Yeah.
Maybe it's also just, I don't know what he's telling his superior there, my lord. I have no knowledge of this document, my lord. So it's for Johannes to answer it.
Then we have a statement of Sharon Neumbo, which was part of the Namgoma bundle. On that issue, to show why the MOU was of importance to go to the minister, because
My lord, before he goes on, may my learned colleague provide a copy, as I indicated. If he has a copy, so that we follow.
I'm just getting to the document and then he's already up.
Well,
My lord, procedurally, it should be, because I shouldn't ask for documents. I'm entitled to them. Just like when we started the applicant's case, my lord, evidence in chief, we provided documents that we're going to use. We didn't require the state to ask for them. So if my learned colleague, before he refers to a document, he should be courteous enough to provide me with a document. I shouldn't ask for it, because I need to follow.
Mr. Ipinge, were you not going to share the document with Mr. Siomunji?
My lord, there's no way I could not. And in fact, if he was ready enough to do this bail application, he should have gotten the record of the previous bail application. And then he would have all the documents.
Is that to say the previous lawyer of the applicant should have these documents?
Yes, I brought them before.
Yes. But certainly in this court, Mr. Siomunji, you made that point earlier already, and your colleague was just laying a basis for his question, and he would not have asked the question without really disclosing where in the statement, and you also satisfying yourself. Is courteous enough to do that. So the court will ensure that that happens. So you don't have to worry with having to raise this issue. We'll ensure that you get the documents that he's making reference to.
May I please the court?
Yes. But may I find out, you could not be provided, who assisted him previously?
Mr. Biekes and Mr. Metcalf.
And Mr. Metcalf. What is the status of the record? Because if it's part of the record, that's why I'm not asking for these documents. I already have them. This is a bail on new facts. They remain part of the record. They could not provide you with those files.
My lord, the issue is there's so many documents that were used then.
Okay.
We do not know, because I obviously, Mr. Ipinge, assisted by Mr. Marondeze, would know which documents they want to rely on.
They want to rely on.
It might not be everything.
Okay.
Yes. So it's the issue of courtesy, my lord, comes in when at least I'll let your colleague, these are the documents I intend to use. You provide copies so that we are on the same page.
Before he starts with the...
Indeed, so my lord.
Also,
I
that's
don't need
your
to
point.
be asking for the documents.
Okay. 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 Are you able to
I gave it
extend
to him
that
already.
courtesy to your colleague? Let's say we still have the afternoon, we still have tomorrow. If you are aware of the documents you might want to rely on for purposes of cross-examination, which were already handed to the court, that maybe you could indicate to your colleague. Is that possible? Okay, let me pack that one. Maybe we'll revisit it later.
Yes.
You'll continue with cross-examination.
You see, I'll read to you what Sharon Neumbo said in his statement. It's at page 347 of the bundle, which were previously marked as Namgoma. At paragraph 14, It says, after this meeting, I began to lobby our board members to agree to sign with Cutler. James assisted immensely with this as he was taking the time to speak to the people when I asked him to. He would tell them that this is part of the minister's plan in order to convince them. He also assured some of these people that if we comply with the minister's wishes, we would be guaranteed a larger quota than other companies. You see the importance why this MOU was just not for you. It was also for the minister.
Just for clarity, I'm not following. He said 347. I see maybe the statement is not complete because mine only goes up to paragraph 4.
Okay.
Go to the next page.
There is no next page.
Go to the next page after that.
There is no next page.
Go to the next page after that one.
Kindly pass on the file to them to
If
assist.
I may just approach my learned colleague.
Yes, so that they can assist.
Paragraph 14.
What has been clarified, the next page, what I was referring to, no, I just want to get
Yes,
it
no,
clear.
no, I can see it's a different document
Yes.
after the first page. I can see
347
that. Yes.
is the statement of Sharon. It goes on to paragraph 4. The next page, 348, is a document from Ministry of Fisheries and Marine Resources.
Yes, I can see
Yes.
it. It's a different document. But at least, did they manage now to show you the right document?
The numbering, yes, they showed
Yes.
me, but it's completely not done properly, and that's why I was saying that I'm not following.
Yes, no, I understand. Thank you.
I'm glad my colleague have it. You see there. That is what exactly. Just hold on.
Okay.
That is exactly how, even with the JVs which you are not charged with, even for the MOUs. That's why we said in your previous bail application, what took people like Harold Pupkewitz, Willie Umed to do in a year, which they failed to do, took you but 1 month. Because you had external powers, you had the minister with you. They were promising greater quotas. If the JVs sign up with Samherji, the minister will give quotas, extra quotas.
I disagree with that, my lord. So, my lord, if you go to my bundle of document 20,
Yes.
where it says JV meeting, it says the heading is JV meeting, document 20.
Bear with me. Yes, I see it.
It's an email from Sharon Neumbo, sent to
Yes.
Johannes Stephenson, CC James, and myself, T. Hatuikulipi. You see that, my lord?
Yes, I have it.
If you see there, it says, Johannes, trusting that we are doing well. I'm sitting in this meeting and Katla is trouble coming. And if you go to the, I think it's paragraph after now, whatever she have mentioned there, it says, anyhow, brace yourself and expect a major fight that the parties copied might need to assist you again. Who are the parties copied? Tamson Hatuikulipi and James Hatuikulipi.
Where do you differ on this issue? Why are you saying you disagree with the way he's putting the question? He's saying, apparently, what
That's an
took...
affidavit, right?
Yes.
He's saying that's the statement. That was, I don't know when was it signed.
How is it different from this
It's
one?
different because this one it does not say the minister have assisted.
Oh, okay, that's
Yeah,
the
it's
angle
saying
from
the
which-
parties that have been copied here.
Okay.
Yes. And I'll demonstrate further. Before I get to that.
I'm
part.
done. I'm done.
I'll demonstrate further. Continued with 26 September 2012. There was a meeting, and I'm referring to document number 23 in the email bundle, the smaller bundle.
Which bundle was this one?
Yes. Go to document 23 on top there. It was previously marked D14.
I see that.
Present at this meeting is the big man, as referred to in the email, and James. You see there?
I see.
The following is being updated from Johannes Stephenson to Adelstein Hagelsen, Siggy, and the others, correct?
I see that.
This is what they were talking about. That NAMSOF held a presentation in the ministry last Monday to justify the contention that they should continue to retain the largest part of the TAC, which is the total allowable catch for horse mackerel. You see that?
I see.
Then it says they got a negative response from the minister, and this will not be permitted.
See that.
The big man, previously in my bail application, I have taken you to the documents where the big man is referred to the Minister of Fisheries. Remember that?
Then I say I don't know who the big man is.
Yes.
Yes.
I stick to that. The big man is pleased with the course of events at Katla today in the negotiations with the JVs. He will talk to those that he knows in the JVs, as he has done, to give Katla his recommendations and to urge them to work with Katla. He stresses that we should contract with the JVs no later than the end of October, as the TAC, which is the total allowable catch for 2013, will be announced in the second week of November. In other words, the minister will be talking to people, even himself in the JVs, to sign with Katla. So you are immensely assisted. And that is why, time and again, you are referred to as the son-in-law. That is why you had to prove that you are son-in-law, because you are going to get the assistance of the minister. What is your comment?
I disagree on that, my lord.
And
I have no knowledge. Let me just finish.
Okay.
I have no knowledge of this document, my lord. If you go to my document, my lord, document 11, my document. It says, it's the email from Johannes sent to James, Tashi, and myself. It says JV1 and 4. Hi, James. Okay. Here are a few points. It is very likely that most quota JVs will negotiate with the operators for several months, possible until November and December. But we will try to secure them within 1 and 2 months. That's now where we are copied into, my lord. And this one, I have no knowledge of this document, my lord. I don't even know who the big man is. Even the same question was put to Mr. S. I was listening. And then he said he's not the big man. But Mr. Ipinga is saying he's the big man. Maybe gave him a new name now.
that is exactly what they were referring
Where I'm
to.
copied, it says within 1 or 2 months. This one, I have no knowledge of this one, my lord.
But from what I'm reading, from this document,
That's why I'm saying I have no knowledge of him.
Yeah.
The one that I have knowledge is this one that was copied to me.
hold on. From the document, which is an email that is in possession of the state, it clearly shows that the minister was talking to the JV members to give them his recommendations.
But in the same document, it says they got a negative response from the minister, not from the big man. And here I say the big man is pleased. Which one is which now? Here is the minister. They got a negative response from the minister, and this will not be permitted. The following, the big man is pleased. Which one is the big man? Here he said the minister is saying the big man. Now your document.
Yes.
I'm
The only
sorry,
one
my lord, I'm
present.
not allowed to ask questions. I'm just referring to this document.
Well, that's fine.
Okay,
It's
thank you,
helpful.
Madam.
And that has been clarified already.
Now, which
I've
one is
shown you.
wrong? Here
That-
it does not say the big man, it says the minister. Now you are saying the minister is the big man. Why did you not say the big man is the big man? Respond in this meeting.
You remember when I asked you from the beginning that I have, in my previous bail application, referred to you that the big man that was being referred to as the Minister of Justice, of Fisheries. You refused to answer on that. You say you do not know about that arrangement.
Yeah, that's what I
Yes.
said. Okay,
Now,
thank you.
from here, from this document at least, it clearly shows that the big man, who I have explained to you to be the minister, was giving the JVs his recommendations to urge them to work with Cutler. That is what is at least written in this document.
My lord,
That I have no knowledge of.
You have no knowledge
Yes.
of that.
From what
No, I
has been
understand
responded, my lord.
your answer.
My lord, I object. The applicant raised a valid issue, which is for issue of clarity. He was not asking a question. Because if my learned colleague is referring to the same document, this D14, it mentions big man and minister. Two different people there. So it cannot refer, his own document that he has introduced is not referring to the same person. That is misleading.
Mr. Ipinge, does that change your position?
No, my lord. I've already made it clear to the witness
Okay,
why.
so minister and big man, one person?
Yes,
Okay.
that has not changed. Good. Right. Now, you see, we have now dealt with the MOU because that's what you started off with when you were dealing with. Just keep it with yourself there. We have that's what you started off with when you presented your emails, which are under divider 2. Right. Now, all these emails have to do with whatever transpired between the JVs and Samherji, correct?
That's correct.
You, before this court, have not been charged with any transactions relating to the relationship between Samherji and the JVs.
That's correct.
In court, the court, when you're testifying, in this bail application now, the court asked you, what was your understanding of the state's case? Is it that we are alleging that you were never involved in the JVs? Is that your understanding?
Did not render any services. The reason why I brought these documents is because they are saying that I entered into a dummy agreement. So if you look at the facts, the new fact that we brought, I said the applicant will produce various communication and correspondence with various entities and people, including Mr. Johannes Stephenson, to prove that he generated his income purely from business perspective. And this will contradict what Johannes Stephenson stated in his affidavit, that agreement entered into a merely dummy agreement. So I brought this document now to prove to the court the agreement that I've signed between Samherji and my company, they were not dummy agreements. They were related to these documents, my lord.
Is it your understanding? What
No.
is your understanding of the state? Is it the state's position that you never dealt with Samherji and the JVs?
I never rendered any services.
Is that what?
Money that was paid to me was bribes money. That's what the state has been alleging, my lord. Now I said I was never paid bribe money. That's why I brought this evidence to prove why I was paid.
All these documents that are here in file divider 2 does not talk about payments, correct?
Does it not? Are you sure, Mr. Ibino?
Where does it say? Here is a payment for your services between the JVs and Samherji.
Go to document 33.
Yes.
It's a Cutler invoice. It's an email from Johannes to Tamson Hatuikulipi. Hi, Tamson, if you say
You
that
say 33.
Yes, 33, sorry, my lord.
Yes, you may proceed.
It's an email from Johannes to Tamson. He say, hi, Tamson, if you say the VAT is inclusive, it will be a problem for you. It should be excluded. As you should get the whole amount. What whole, regards Johannes, what whole amount are they talking about? It's a payment.
Yes.
Yes.
For what?
For
It doesn't say
for
anything for what.
For services rendered. The invoice is clear, my lord. The description of the invoice, my lord, it says consultancy fees. In that description is backed by the agreement between myself and Samherji. And those services are defined in those agreements, my lord.
In that email,
You ask for what? I'm saying for
yes,
services
that
rendered.
email that you just read to the court, from it without interpreting it yourself, from it that as you presented it, does it specify what that payment is for?
It does not. But
It
on
does
the
not.
invoice, it's specified as for consultancy fees.
Is there an invoice attached to that email?
No, the invoice is not here. It's not attached, but the invoice is available. If you look at even,
Yes.
if you go into my bundle for the previous bail application, my lord, there is a ledger there of payments that was made. If you look at that date, 2nd December 2014, it shows that there was a payment done on that same day.
And the only thing that that invoice reads is consultancy. That's it.
Consultancy fee. Do you have the invoice there?
Fees.
Do you have it there?
No, no. All your invoices I'm talking about.
They say consultancy fees.
Fees. Yeah.
Yes. Because they are backed by the agreements, and the agreement defines the services. So the court must consider that on that background, my lord, that there is an agreement.
Now, for this specific,
Maybe, sorry, Mr. Ipinge.
yes.
You said the ledger is contained where?
Let me just get, may I?
Yes.
Okay.
Which bundle is that, Mr. Hatuikulipi? Was it used in the previous
The
bill?
previous bill application, my lord. My bundle that I provided, my lord.
Okay.
It's a divider 13, my lord. It says on the 2nd of November 2014 was a payment of 2.1 million paid. That's right. Okay, 9 December, my lord. Sorry, my lord, 9 December 2014. See the 2.1 there.
Well, I don't have that
Oh, okay,
bundle, but
9
it's fine.
December
I'll have a look at
2014.
it. So you are saying that ledger explains this payment?
Correct.
It
Because
says
this says on the 2nd, the invoice was on the 2nd of December 2014, and then there was a payment now made of 2.1 on the 9 December 2014.
Okay. You were saying it's for consultancy.
It's for consultancy, my lord.
You'll
Now-
proceed.
Can you tell us on that specific, for that December when you invoiced, what consultancy did you actually carry out? What did you render to Samherji for that 2.1 million?
My lord,
Can you break it down for us to say this 2.1 million, 1 million was for this consultancy, 1 million was for doing so and so, 500,000 for us. Can you do that?
it's difficult for me to break down,
Yes.
my lord, because like what I've said, these funds were commingled.
They
And
were what?
They were mixed, commingled. They never indicated that this money is now for the clients that I brought that was buying from Samherji, or is it for upon the success of the JVs that I brought on the table, my lord? Yeah, so it does not. And this was only cleared if we go to document 59 of my bundle.
The previous one.
No, this the current one.
Okay.
It's an email from a, okay, sorry, my lord.
Yes.
It's an email from
Yes.
It's an email from Agil sent to me, CC Irene Rodriguez. Dear Tamson, can you change the concept of the following? From our side, the concept is not accurate. Please see below. So the old discrepancy was consultancy fee, and we have to be changed to sales deal. This came about, my lord, when I invoiced my invoice for service provided, and I referred it as to consultancy, like the way we used to do it before. Now I was asked to change it to sales deal commission. Now here it's been clarified now, it has been rectified now here, my lord. They've now indicated that 7.8 million, it was from the sales deal.
For which year was that?
This is 2019. Yeah. But all along, my lord, we have been invoicing as consultancy fees. Even if you look at document document 53, my lord. Those invoice, oh sorry, my lord.
Yes, I'm following.
Yeah, document 53 of my bundle that I've now provided.
Yes.
It indicates it's an email from A, where you say, good morning, sir. The attached invoice for JTA trade is not valid for VAT purposes. It was selected by the Ministry of Finance for VAT audit process. The invoice states invoice, at the top it should read text invoice. So, my lord, even the ministry had never issue of the invoice saying consultancy by this time. It still says consultancy. The only issue they had is that it only indicates text. Oh, sorry, it only indicates invoice, but not text invoice. They never had a problem of this issue of consultancy or what. They only brought this in 2018. But all those years, the invoice were consultancy fees. And the same invoice was brought by their state witness, that she is referring to as Sharon, with the same description, consultancy fee, which is document 54. The same invoice assurance one, it's a consultancy fee.
Okay. No, I
Well,
think no.
thank you, Alan.
We'll come to the invoices. But
Yes, it's fine.
maybe, yeah, my learned friend had courteously
Is it 12?
requested that we adjourn at this moment.
Is it
So
12
he
o'clock?
makes it on time for,
Is it time?
yes.
Oh, okay. I maybe just on that point,
Okay.
this consultants, is it the one that was done by Mr. James Hatuikulipi?
That's correct, my lord.
Oh, okay.
That's correct, my lord.
So we'll proceed at 2:15.
Has it got-
That's in order, my lord.
All right. Court adjourns until 2:15.